Schyler Church. I am a California real estate broker as well as a member of the education department here at Accredited Real Estate Schools. We offer those course requirements to be eligible to take the state exam, as well as varying levels of preparation to help you prepare for that state test. So we are going to go over some of our practice questions to help you prepare. If you like these, make sure to check out our website below, as we have a link if you want access for a year to our database of 3,600 practice questions. It's only $50, but let's get going with it and start with question number 1. A Subdivision Map Act requires that submissions for approvals be made to A, local government officials, B, corporation commissioner, C, real estate commissioner, D, none of the above. Well, what do we know about the Subdivision Map Act? That is where it applies if you're going to subdivide, so divide a parcel into 2 or more lots. So when that happens, you have to get the approval from your local government officials. That is the Subdivision Map Act. Now, if we were talking about the Subdivided Lands Law or Subdivided Lands Act, that is if you were to subdivide a parcel into 5 or more. That's then when you'd have to get the local government officials, but also the Department of Real Estate involved and get the commissioner's approval. But that's if we were talking about the Subdivided Lands Law. Right now, we're just talking about that Subdivision Map Act, which is 2 or more, and you have to get your local government officials, so the city or county involved where the parcel is located. 2, concerning a subagency relationship, which of the following is most nearly correct? A, sellers are not responsible for the conduct and representations of subagents. B, a cooperating broker working in a subagency relationship owes total loyalty and fiduciary duties only to the buyer. A subagency relationship usually reduces the number of agents working on the seller's behalf. D, a broker is not required to accept an offer of subagency. So what do we know about subagency relationships? That is when a broker takes on a salesperson or a broker associate and puts them under their license. That is then when the subagency relationship is established, because the broker establishes the agency, and myself as a broker, I can represent buyers and sellers by myself. However, as a broker, I can take on salespersons and place them under my license and manage and supervise them. By doing so, if I have a salesperson or a broker associate under my license, well, I could then have them be the main point of contact if I wanted, but I still establish that agency relationship. So the salesperson working under me would be the sub-agent in the sub-agent position. So that is how the sub-agency relationship is created. What do we know about this? So sellers are not responsible for the conduct and representations of sub-agents. Well, sellers are responsible for their agent that is representing them and any sub-agent then that is appointed and also working under their the agents. So that agent relationship. So that is incorrect. The sellers will be responsible for the conduct and representations of those sub-agents that are working under the agent that they had hired. B, a cooperating broker working in a subagency relationship owes total loyalty and fiduciary duties only to the buyer. So a cooperating broker working in a subagency relationship. So let's see here. This is a very old term, very, very old term of what they're talking about here. We're not going to get really into this, but just know whenever you're working under somebody and working as a cooperating broker, let's just say you're working as a cooperating broker. Well, do we know if you're working as the buyer, representing the seller? We're not 100% sure on that. But you also have the duty of honest and fair dealing to the other third parties in the transaction. You owe a fiduciary duty to your principal, but then you owe a duty and honest and fair dealing to any other third party within the transaction. So it's a very old term. It's weird. Let's just keep it there. Let's see if there's a good answer then. C, a subagency relationship usually reduces the number of agents working on the seller's behalf. No, whenever that subagents are in the equation, that's adding the amount of people that are working on the seller's behalf, because the agent is the broker, and then any subagents that the broker appoints, well, those are subagents. Well, they're going to then be working also on behalf of the principal, so the seller. So it's going to increase the number of agents working. That's incorrect. D, a broker is not required to accept an offer of subagency. So what's here? So a broker, do they have to have subagents? No, they do not. They are not required to accept subagents, and they're not also required to have cooperating brokers where they have to share their commission unless that agent decides that they are willing to cooperate and work with other brokers. So no, they are not required to do so. That is the best answer. And then we have question number 3. The city announces that it is taking 10 feet from the residential property to widen the street and facilitate traffic flow. This would be considered A, functional obsolescence, B, an inverse condemnation action, C, illegal with the owner having recourse in the courts, D, economic obsolescence. So let's see here. The city is taking 10 feet from a residential property to widen the street and facilitate traffic flow. They are taking private property for public use. This is a condemnation action that they're doing through the power of eminent domain. They are taking private property for the public good as long as there's just compensation. But when they do so, they have now reduced this property owner's property. Well, at that point, they are now losing value because they have actually lost property. And whenever you're losing that, you're going to lose value to it. And this is due to outside external factors. They didn't cause it. The property owner didn't cause it, but the city is causing it. So that would be due to external factors, a loss in value. We attribute that to economic obsolescence. Why did they do so, though? Because it was a condemnation action through the power of eminent domain. That's one of the sovereign powers that the state has. They can take private property for public good as long as there is just compensation. Well, that would be, when that happens, that would then their loss in value the property owner has would be attributed to economic obsolescence, that loss in value due to external factors, which is the city taking part of their property. And then let's just look at functional obsolescence. Remember, that means that means a loss in value due to styling issues that are within the property lines. Inverse condemnation action, that is when the property owner forces the government, or the city in this case, to take their property, which they're not in this example. And the city can do so. That is legal. But the owner could have recourse with the courts. They could try to fight this condemnation action, but it is technically legal because of the power of eminent domain. That's why the best answer is economic obsolescence. 4, a broker negotiates a deal between buyer and seller and then opens escrow. The buyer deposits a check directly into escrow. The broker must A, log the deposit in his trust account under undeposited funds. B, only log it in his trust account if it goes into his account. C, not log it into his trust account unless it is within 5 days of the contract date. D, none of the above. So the brokers negotiated this deal between the buyer and seller. There was a contract. They opened escrow. That buyer's deposit went directly into escrow. The broker never touched it. Well, since the broker never touched it, it's not going to be put in his trust account ledger because he never put the funds in his trust account. However, because he talked about funds in the contract, even though he never touched it, it went directly into escrow because we referred to funds. It has to go into a ledger of undeposited funds. So it would go into the undeposited funds ledger. Even though he never touched it, he never deposited it, it would go in the undeposited funds ledger. It wouldn't go into his trust fund account ledger, but it is undeposited funds. Yes, it would go into that ledger. So even if a broker doesn't have a trust account, so they don't have a trust ledger, they must have a undeposited funds ledger, because even though they never touched money, they talked about it. So that needs to go into the undeposited funds ledger. 5, when a real estate broker has an exclusive listing, she may be subject to disciplinary action from the real estate commissioner by doing which of the following? A, negotiating her commission above 6% of the sale price. B, asking the seller to sign a 6-month or longer exclusive listing agreement. C, not giving a copy of exclusive listing to the seller and not including a definite termination date for the listing agreement. D, all of the above are correct. When would the commissioner, the Department of Real Estate, get involved for disciplinary action against a real estate broker for an exclusive listing? Remember, this could be an exclusive authorization and right to sell listing agreement. This could be an exclusive agency listing agreement. Well, what do we know about this? Well, an exclusive authorization, you get paid a commission no matter what within the listing period. Whereas in exclusive agency, you get paid a commission no matter what unless the seller sells it themselves. When would the commissioner then get involved if they had done something wrong? So negotiating the commission above 6% of the sale price. Doesn't matter. You can negotiate it for as much as you want. That is between you and your principal. Now, if it is a residential property of 1 to 4 units, you do need to disclose this negotiability of commissions, but the commission amount is not set by law. So if you get 20%, more power to you. It is not something that would be disciplined. However, would the commissioner get involved if the improper disclosure of the negotiability of a commission? Yes, but not the actual commission percentage. Asking the seller to sign a 6-month or longer exclusive listing agreement. Again, when we know about exclusive listings, there have to be definite termination dates. By law, there needs to be a definite one. Now, when that definite termination date occurs, that they don't say. There just has to be one. So even if it's more than 6 months, does not matter as long as there is a definite termination date. That's okay. Not giving a copy of the exclusive listing to the seller. That's a big no-no, as well as if you do not include a definite termination date for the listing agreement. For exclusive listing, they have to have a definite termination date, and the seller has to receive a copy of the listing agreement. Both of those are requirements, and if you don't do so, well, you would be subject to disciplinary action by the commissioner.
Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up, as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions, or if you'd like to check us out for completing coursework to be eligible to take the state exam, or even for preparation to help you prepare for the state test, we have tons of options, and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.